Good evening, friends. On behalf of WRC of ICI, I welcome all of you for this today's webinar. Before proceeding further, I request all of you to please place your hand on your chest for our institute's motto song.
य एष सुप्तेषु जाग्रति य एष सुप्तेषु जाग्रति कामं 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 कामपुरुषो पुरुषो निर्विमाणः निर्विमाणः तदेव शुक्रं तद्ब्रह्मा तद्ब्रह्मा तदेवामृतमुच्यते तस्मिन् लोकः शतः सर्वे तदूनात्यपि कश्चन एतद्द्वैता 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 एतद्द्वैता.
Thank you all. Dear friends, at WRC, we keep organizing various programs on various topics, and our GST committee of WRC is one of the vibrant committee under which we organize various workshop programs and seminars for the students and for the members and students, and also various publications. Our today's program is one such endeavor where we'll be covering a topic of applicability of various criminal provisions under GST Act. And we are really fortunate to have learned experts for this wonderful, this important topic of recent relevance. And I welcome on behalf of WRC Advocate K. Vaitheeswaran sir for this program. I welcome Advocate Kartik Garg. I welcome Advocate CA Ishaan Patkar, who will be moderating this session. I also welcome our WRC Chairman Murtuza Katswala and today's coordinator CA Aditya Maheshwari. Dear friends, under GST committee, we have also started the sectoral series and GST litigation series. I also request all the participants over here to do participate in those sectoral series programs as well as litigation series. It will be beneficial, and faculties are very good, and the content wise the program feedback is also very good. So do participate in those programs as well, and also do let us know if any topic you want to be covered under WRC programs, so that we can work on that. Before now proceeding further, I request our WRC Chairman CA Murtuza Katswala to please address all the participants.
Thank you, Yashwant. At the outset, let me welcome and thank Advocate K. Vaitheeswaran sir, Advocate Kartik Garg for accepting our invitation and joining the panel today. And I also want to welcome and thank CA Advocate Ishaan Patkar. Ishaan, extremely grateful for all the good work that you do for ICI. Thank you very much. Let me also thank Aditya Maheshwari for coordinating the today's program, and Aditya also keeps on coming on our programs and supports us. So Aditya, thank you. See, this year, friends, at WIRC, the theme is leap towards excellence, achievement and development. And we are saying for overall development and to achieve value, like it is very, very important that we have in-depth knowledge about the subject so that we can add value to the client. And which is where, to achieve the theme, we identified 5 goals this year. And for against each goal, we got multiple activities and we identified multiple marking criteria so as to ensure that we achieve them and deliver them. Now, let me touch upon two important goals today. The first goal is updating the technical knowledge of the chartered accountant members and students. And the second is updating the technology advancement and the technology knowledge. When we talk about technical subjects, so like be it income tax, be it GST and indirect tax, or be it accounting standard and company law, we want to ensure that people get in-depth knowledge. And this year, the indirect tax and the GST committee chairman is CA Yashwant Kasar and the vice chairman is CA Gautam Lat, and I want to really congratulate them and thank them for the excellent work being done under this committee. Like Yashwant was mentioning, the sectorial series, 15 different industries will be covered. So like we got an expert speaker last week on travel and tourism. There will be one on real estate. There will be one on something else. So each industry, and they will cover the GST nuances or the complication in that industry, so that as a GST practitioner, if we are dealing with client in those industry, we know the minutest details and we'll be able to add value to the client. So I think extremely great work. Again, the litigation series also good, and today's, in view of or in the backdrop of what happened in Gurgaon, it is very important for us to know that where and what can be done and how do we deal if we get into such type of situation. And I think today these advocates who are here with us, they're going to touch upon all those aspects in the GST Act and what care we need to take and what can and what cannot be done to a practicing CA or a consultant. So I think that is what is going to be covered here, and such an apt topic at the right time. So extremely grateful for that. And again, lot more. There is like a lot of publication. The indirect tax committee even did an outreach program. So there is so much more which is happening here. In addition, I want to touch upon only two more aspects in the next 1 minute. So like at WIRC, we are even planning multiple refresher courses. So the direct tax refresher course is starting on 18th, next Saturday, 18th Saturday, and it will be 4 days, 8 speaker, 12 hours. So we're going more into details. Similarly, an indirect tax refresher is being planned, an IBC refresher, internal audit refresher, international tax refresher, and cooperative refresher. There are so many refresher courses which are being planned. So as to ensure that people get knowledge about those area, then where do you go and empanel, what type of assignments are available and what type of fees do you charge? So that is one. Second, we're doing multiple things on the technology front, be it a course on Excel, be it a course on IDEA data analytics, or a Tableau or a fusion of Tableau with Excel, on even a longer duration course on data analytics. So we have we launched 2 courses. Part 1 is data analytics, where we teach hands-on Python and SQL, coding on Python, writing queries yourself. It is in Saturday evening and Sunday morning. You can sit at home and do 60 hours, only 9,000 rupees fees. Part 2 is like Power BI and Tableau, where you can do the presentations, and 40 hours, only 6,000 rupees fees. So I would request that please join these courses. If you go outside, this will cost you more than 1 lakh rupees. And the best of faculties, part 1 we completed 4 batches, 5th batch is going on, only 30 participants per batch. Part 2 you completed 3 batches, 4th is going on, only 25 participants per batch. So hands-on experience with data on procure to pay, order to cash, etc. You can learn and you can then adopt the technology in a day-to-day work. So I think extremely grateful to the participants for joining, and thank you very much and happy learning to all. And over to you, Yashwant, again. Thank you.
Thank you so much, Chairman Sir, for briefing our participants about the various WRC activities that we are organizing, conducting. Now I request CA Aditya Maheshwari to please introduce our learned experts or the panelists to all our participants.
Yeah, thank you, Murtuza sir, Chairman sir, and Ashwin sir, Vice Chairman. So good afternoon, members. It's a pleasure for me to introduce our today's speaker, which are a nice blend of speakers from Mumbai and Chennai, and we are going to deliberate on a very hot topic, as mentioned by Chairman sir also, that in view of the happenings in Gurgaon, the applicability of various criminal provisions under GST with major focus from CA perspective. First, I would like to introduce Advocate Kartik Garg from Mumbai. He has done his LLM from Mumbai University and is practicing since 2012 in Bombay Court exclusively on the criminal side. He joined the chamber of SV Marwadi in 2011 and he has been independently practicing in the High Court and Trial Court since 2015 and specializing in white collar crime. He was very recently been appointed as a public prosecutor for the central government. So we congratulate him for the achievement, for the role. Sorry. We welcome you, sir. Secondly, I'd like to introduce K. Vaitheeswaran, sir, from Chennai. He obtained his law degree from Madras Law College, and enrolled as an advocate in 1990. He is also an CWA and ACS. Before starting his own firm in 2000, which currently operates at Chennai, Bangalore, and New Delhi, he had joined Subbaraya Iyer Padmanam and Raman Mani Advocates in 1990 and became a partner in 1998. He has over 29 years experience in the advisory capacity as well as through appearance before appellate authorities, tribunals and court in matters arising from domestic and international tax laws, excise and customs, service tax, VAT, CST, GST, FEMA, RERA, company law and IBC. I think he has covered all the sectors which we could deal with. He also considered as a specialist in tax and legal matters within depth knowledge of business and tax laws, advising clients across the country on various verticals. He has addressed over hundreds of seminars and conferences on law and taxation across the country and abroad, and he is most sought after legal profession in GST and business restructuring matters. He is an expert on real estate contract and recently followed into technology law and artificial intelligence. He wrote his first comprehensive book, VAT in India, in 2005 and co-authored book on SENVAT credit, books for students appearing in CA final, and he has just completed book on taxation on digital economy. He is a chairman of expert committee on GST, Madras Chamber of Commerce and Industry, and also member of General Committee of Madras Chamber. So we welcome you, sir. Third and last but not the least, we welcome CA Advocate Ishaan Patkar, who is an advocate practicing in Bombay High Court. He is a chartered accountant by profession. He practices in commercial and civil laws and regularly appearing before NCLT in arbitration matter and other matters. And he has worked with senior advocate V. Sridharan as his junior for 2 years before starting counsel practice under Gautam Ankad, advocate in civil and commercial law side. His book GST Law Guide was published by Taxman in August 2017, and another book on concept of supply by BCS in 2018. He has published a digest of judgments of Supreme Court, Bombay High Court and Maharashtra Sales Tax Tribunal from 2009 to 2014 through Sales Tax Practitioner Association of Mumbai. He was a member of Indirect Tax Committee of ICAI and a member of Indirect Tax Committee of BCS. Currently is Managing Committee of Goods and Service Tax Practitioner Association of Maharashtra and All India Federation of Tax Practitioners Western Zone. And is the founder secretary of Confederation of GST Professional and Industries. He has addressed various seminars on GST organized by various forums and associations, and a regular contributor on GST and VAT in various journals. So with this, I welcome all the three speakers to this webinar. And request to take Ishaan sir to take over.
Am I audible?
Yes.
Yes, so I welcome all of you and many thanks to the chairman sir and Yashwant and Aditya for the kind words. And truly this session is really need of the hour because of the shockwaves created by the arrests in Gurugram. My mandate was to actually focus on arrest of CAs, but I have formulated questions which even deal with arrest of clients. That is because most of the answers will be same. Secondly, as consultants, we need to know what our client is going to be exposed to also, not just what we are going to be exposed to. So we'll deal with both of them. There are some CA specific questions. Most of them otherwise apply to both of them. That is one thing. Secondly, both the panelists were concerned कि questions को answers क्या दे. There are no settled, there is no settled jurisprudence in this area actually. So that is why even I thought that I'll clarify that the views which will be expressed are of course as per their understanding now. None of these provisions have been tested in courts. I think Kartik was only telling me कि अभी तक income tax का कोई prosecution complete ही नहीं हुआ है. ट्रायल चलती ही रहता है. सेल्स टैक्स का तो मैंने प्रोसिक्यूशन ही नहीं देखा है आज तक. धमकी देते हैं, शोकॉज नोटिस आता है, उसके आगे कुछ नहीं होता. So we don't know if any of these prosecutions under income tax, VAT, at least in Bombay, have actually achieved any final, even have proceeded beyond trial or even trial is commenced. And therefore, what views courts are taking is a bit difficult, except that assessment, whether it has to happen before or after the arrest, that is the only judgment I believe which is there till date. So whatever views both the panelists will take will be as per their understanding, but it is always subject to what ultimately the court holds. And no one really has the correct answer to all the questions, but there are some 26 questions that I have framed. I don't know how much we'll be able to complete, but at least the main questions I'll ensure that we complete. And so we'll start with the first question, which is to Mr. Vaitheeswaran. Sir, this section 132.1, the opening line was amended with effect from 1st January. This is question number 1 in our sheet, sir. Was amended. If someone can put the sheet also on the screen, I don't mind. I don't know how to use this particular software. But that section 132.1 opening line was amended to add the words causes to commit and retains the benefit from 1st January 2022. Now, firstly, what is the importance of these phrases and whether this can be retrospective or prospective? If I may just read that whole line so that members can get context, that A, B, C, D, E are the offenses, but the first line where 132 subsection 1 begins, whoever commits or causes to commit and retain the benefits arising out of the following offenses, namely. Earlier it was only whoever commits any of the following offenses. So sir, what is the importance of these two phrases and whether amendment retrospective or prospective according to you?
Good evening. Hi, Ishaan, and hello, Mr. Kartik, and dignitaries on the panel, members from the institute. It's something interesting that excise had its own battery of provisions which dealt with offences. VAT had sections which dealt with offences. Income tax has always had provisions dealt with offences. And typically, in a tax matter, I would lightly put it as fiscal consequences and physical consequences. So fiscal consequences, your interest and penalties. Physical consequences, the lawmaker feels that a message has to be sent to the country so that people don't do this again, or others are inspired not to do this again. So that was always the objective behind having strict and stringent offense-related provisions. But if you look at the history of central excise prosecutions, it has not been that significant. If you look at the history of VAT prosecutions, wherever it has come up, it has been very, very nasty cases of evasion, of all kinds of manipulation, all kinds of record manipulation, and great levels of suppression and things like that. Whereas the GST has, right from beginning, has always been in the limelight. Right from beginning, GST has been so popular that even the penal provisions have become popular. So the offense provisions in GST law has taken the country by storm. And it is as if all the authorities are also thinking that some new provisions have come and they have to implement these new provisions with zest and vigor. And that is why you see all kinds of action throughout the country. With that in mind, if I were to read the amendment, which just now was read out. Whoever commits or causes to commit and retain the benefits arising out of any of the following offences, right from A, B, C, D to the last 1. Now this has come through Finance Act 2020 with effect from 1/1/21. But if you look at the background, there is an interesting minutes of the GST Council, the 38th GST Council meeting, which was held on December 2019, where it records, the agenda records, I'm just quoting, it has come to the notice of the council that in many cases, the modus operandi was that there would be a mastermind who engages persons like daily wagers, rickshaw pullers, etc., to open multiple firms, to issue invoices without supply of goods or services, to pass on the ITC. Such masterminds also arranges for actual suppliers of goods or services to whom, on payment of agreed amount of money, these invoices will be sold. These suppliers then avail this fraudulent credit tax involved in respect of the fake invoices and then utilize this credit either to discharge tax or take fraudulent refund of the tax on export of overvalued goods. In the entire operation fraud, the person who is the mastermind is the key person who abets or causes the commission of an offence. But in the present scheme of GST law, stringent penal provisions are not available for such persons causing or abetting the offence. So if you read the amendment with the background, because all the amendments are made based on the recommendation of the GST Council, let's not even get into the scope of recommendations, but all decisions are based on the recommendations, and therefore the GST Council had felt that this fraud of fake invoice has to be taken severe action with, and they found that there is a mastermind in all these transactions. So if you're a big Money Heist fan, we're talking about the professor. So if the professor who's behind all these things is the person who's supposed to be captured in this amendment. Therefore, I would feel that causes to commit is a very serious amendment which has widened the scope of persons who are covered. That does not necessarily mean everybody in the chain. The poor chartered accountant is advising the transaction or advising the filing the return or taking care of assessments or things like that. That is not the intention of this amendment if you read the council minutes. And interestingly, I would say there is some degree of shooting in the feet by adding some more words in the section by saying and retain the benefits arising out of the offences. So now that is going to be a subject matter of interpretation and dispute, because even in the anti-profiteering, we are still not clear as to what is benefits to be passed on. So and retaining conjunctive clause. So one could probably say that he must cause to commit as well as retain the benefits, and then only he can be roped under 132(1). And if that be the case, then there could be any number of interpretation arising out of that. To answer the second part of the question, since the scope of the amendment is very clear that it brings in a category of persons who was hitherto not covered, and criminal consequences are going to visit that guy which was not contemplated before, it can only be prospective, it cannot be retrospective.
Thank you, sir. So basically, the words retains the benefit also, sir, whether it's only monetary benefit or what, can include other sorts of benefits also. I mean, I can't wrap my head around what it means really. Maybe as we go forward in the discussion, it may become more clear.
Yes.
Now, the second question is to Mr. Garg. Again, with respect to that causes to commit. Causes to commit in section 132 subsection 1, whether it is the same as abatement, because now, as Mr. Vaitheeswaran said, the GST Council apparently to catch that mastermind came up with this, but even while he was reading out the recommendation, I was also reading it simultaneously. They seem to still use the words abet, but that abatement was already an offense, I believe, under subsection 132(1)L.
Yeah.
So if it is the same thing, then the amendment, has it achieved anything new, or it is just something which is just restating what is already an offense?
So if we see basically amendment and the term causes to commit, basically according to me these two terms are quite different. Now abatement has a specific definition under the IPC, which is under section 107, and there are three classes under which a person can be said to have abated an offense. The first basically uses the word instigates any person. So if a person instigates any person, second, that clause uses the term engages with anyone in any conspiracy for doing any illegal act, and the third is intentionally aids a person. So these three categories, a person falls in these three categories, then only it can be said that the person has abetted an offense. It can't go beyond that because there is a clear definition. Now, if we see the term causes to commit, now according to me, if we see this, basically there is no definition of causes to commit so far as my knowledge goes in any act. Even this term, according to me, has not been used in any of the acts which I have seen yet, so far as to define an offense or to include a person under an offense. So this is now open to judicial interpretation. You can say that causes to commit abatement can come under the whole meaning of causes to commit, but it can't be same. The causes to commit is a wider connotation and it may include many persons. So as sir said, the real intention is this only, because we have come across many cases where we have seen that people instead of having companies or entities in their own name, have open entities in the name of their servant or anyone X, Y, Z, and through them they do all these things, all the illegal acts, and they are behind the curtains and nothing happens to them basically, and the prosecuting agent finds it very difficult. And even for abatement you have to prove. So if we go by the judgments of Supreme Court and High Court, for to prove that a person has abated anything, there has to be a direct act. It has to be proved how he has played that role, what he has done. Without that, it is very difficult to bring him under the definition of abatement. So therefore, causes to commit, now this has to be interpreted what it exactly means, because it will basically open a Pandora box to it may include each and everyone. However, we have to read it as a whole. That is, if we see the definition, see the act, it says that whoever commits or causes to commit and retain the benefits arising out of. So if we have to read these two terms jointly, so it can't be that a person only by saying that he has caused an offense to commit can be said to be brought into this. It should be with a person who is the beneficiary of that that offense. So by we can say that the main beneficiary is also brought into the picture by this amendment. So basically it can't be said that abatement and causes to commit is same. It is quite different. Abatement is defined and causes to commit may bring too many people into this who are responsible for the whole offense. Now it all depends upon the courts how it will be interpreted basically.
Thank you, Mr. Kartik. The third question is again to Mr. Vaitheeswaran. If you see this section 132 1A to D are the offences which attract, I believe, the arrest provision in section 69. Section 69 says, just 1 minute. Section 69, you could be arrested if you are falling within 132 1 A, B, C or D, or else under that subsection 2, which is repeat offences. Now the question is, a CA who is accused of having facilitated any offense, does he fall within 132 1A to D, or he will fall within that abatement clause in subclause L, and therefore his arrest permissible under 69? But certainly a CA will not have been said to cause to commit. I am assuming that they will not say that the CA is a mastermind. He may be, at most, he may be accused of doing something to facilitate it. For example, there was in these customs brokers licensing cases, a lot of times the customs broker must not be doing anything, but just because he has not checked or something, or he may have checked, some information is withheld from the customs broker, they slap that abatement clause and then start proceedings against him. So essentially, if he falls within subclause L, and not within A to D, then whether section 69 is triggered is the question.
Got the point. The key question here is, what is facilitation? So the question is, a CA was accused of having facilitated any offense. Now, we need to be very guarded in how we approach this question and look at the various perspectives. I would put professionals under three boxes. I'm not judging here, but I'm just analyzing the provisions in the context of the question that is raised. A professional who is dealing with compliance, dealing with the data given by the client. Based on the data, he uploads the returns. He has all the blood pressure throughout the midnight trying to upload the return. And at 1 a.m. in the morning, he is finally uploading the return. That is one set of professionals. 99% of the professions fall there. The second person is probably a person who advises on the scope and ambit of the law, applicability of the notification, consulting, strategy, business restructuring, planning, agreement, drafting, whatever. He could do all those things. So what I'm talking about is 99% together, both these people. There could be 1% professional who may fit into the definition of the mastermind. There have been instances, there have been few sporadic cases in the country. So let's leave out that 1% for the purpose of our discussion. 99.5% of the professionals fall under the first two categories, where they're either in charge of consultancy or advisory. What is their role? Their role is to engage themselves in a professional activity which is permitted by the institute and the law, and they are not the masters of the data that is provided. Now, this has always been tested in Income Tax Act, because Income Tax Act, if you look at section 278, there is a prosecution mechanism which will trigger for an offense, which is in the form of filing a false return. So where a person is causing to file a false return, knowing fully it is false, then prosecution can happen. And there are decisions to say that what is his role in filing the return, except the data which he collects and looks that it fits the data into the format required under the IT law. So if the role of facilitation is compliance or consulting or advisory, I don't even look at 132 being applicable to that kind of professional. 132 cannot be applied, and it would be wrong to apply 132 on such a activity. But suppose the person has, let us say, obtained registration. Let's go a step further. We will just vivisect this issue a little more. The professional has facilitated in obtaining 50 registrations, GST registrations. And in that process, he is very much aware that these 50 locations are bogus locations, or they do not exist. But he has contributed his expertise, time, and done all those things, and there is a trail of documents and evidence which establishes his role. Then the lawmaker, the authorities would look at 132. But then the question is whether the nature of activities would fit into abatement. Mr. Kartik has very clearly, beautifully brought to you 107. And if you look at 107, he talked about three things in 107: instigates, engage, intentionally aid. So instigates or engages or intentionally aids can definitely fall here. So if you can demonstrate that he has intentionally aided in this, it will tantamount to abatement. If it tantamounts to abatement, then you already have 132(1)(l), which deals explicitly with abatement, and it covers all the offenses above. Once you demonstrate that the nature of offense committed is in the abatement sphere, then your point is valid, that as far as arrest is concerned, it is confined to ABCD. But this is not the last view on the subject. There could be a twist to the story by somebody saying that causes to commit can also be wide enough to cover this, and therefore causes to commit ABCD can trigger arrest. So as you rightly prefaced in the beginning, no, none of us are authorities to conclude on this topic, but there is enough scope for dispute and enough ammunition for both kinds of arguments.
Thank you, sir. The next question is for Mr. Garg. Now, if you see this 132(1)(j talks about tampering with or destroying any material, evidence, or documents. Now, chartered accountants are supposed to, for example, maintain their working papers for some limited period of time under the CA Act. Then under this act also and under tax laws, generally you have to maintain the records for some period of time. But still, what happens? Not everyone may be, especially digital record, everyone may not be maintaining everything. Correct? Now the question is really, where a CA is accused of any offense, what are the precautions to be taken qua the evidence which may go against the CA, so as to ensure that there is no transgression of this tampering with or destroying any material evidence or documents clauses. Now I will explain the scope of the question. I'm not saying that the CA is going to tamper, but because what we are asking really is that what is the level of care which is required with respect to this digital evidence, etc. There will always be some evidence which in totality I may be innocent, but some evidence which may go against me, etc., etc. Generally, what level of care do the criminal courts require with respect to evidence? Once you are accused, pre-accused also you may explain, but once you are accused, what level of care is required?
So basically, we have to see this in this way. First, 132(1)(j) talks about tampering or destroying any material evidence. This material evidence, we have to see if there is any inquiry or any basically inquiry with respect to prosecution. So suppose a client of a chartered accountant is under the inquiry for the purposes of any offenses committed by him. If during that course it comes to light that documents are with a chartered accountant and he with some dishonest intention has been tampering or not providing it or would have destroyed it, then only a chartered accountant can come within this ambit. But let me say this, the primary duty, so basically evidence, this stage comes, let us go by stage. First is the stage of inquiry. Before a prosecution is launched, there is an inquiry which is conducted by a proper officer, and at that time he issues summons under section 70 to he can issue summons basically to any person. This is with respect to any offense committed under A, B, C, D, E, F. It can be anything. So suppose any offense has been committed and he calls upon a person to provide documents or produce document. It is firstly a primary duty of that person who is basically accused or under the eye of the officer during inquiry to produce the documents. The primary liability can never be upon a chartered accountant to produce the documents which is with the clients basically. If we see even section 67, which talks about search and seizure also, the tax officials cannot go and raid the office of the CA. Section 67(1) clearly states that it has to be only the place of business of the registered person, the godown, or where he has kept goods or anything. It is only when it is secreted, if there is reason to believe that the documents or books are secreted somewhere, then only the officer can go and search that premises. So before invoking this, there has to be some reasonable material before the proper officer at that time also to say that the documents are with CA or the chartered accountant, he has himself specifically destroyed or tampered with it. It is not very easy to just allege something. So there may be cases where a summons would have been issued to a chartered accountant and he would have been called upon to produce a document. In such circumstances, if that document is not with him, the first question that would arise is, it is basically the chartered accountant should have had that documents or not. And secondly, if it's in the business in which he need, as Ishaan said, that he needs to maintain during the course for some period of time as provided under the act. So he will have to reasonably basically satisfy the officer, first of all, that it has not been tampered or destroyed dishonestly. Second, any act which is even done negligently cannot come under prosecution, but then onus will be upon him to prove that this is not something done dishonestly or he had taken due care and precautions, and still that has not been done basically. So even if we see this 132, even section 70, when a summons is issued, it is always a duty of a chartered accountant or any other person to state truth. He cannot go on and give false evidence. So it is not just 132 1J, but also section 70. So during an inquiry, there are even there have been instances when the proper officer have that officer who has called for during the inquiry have issued summons, have been told that they threaten that if you don't give information of give false information, will charge you under section 193 of IPC, which basically talks about false evidence. So that is also there, because you can't state, means there is a duty, solemn duty to state truth before him. So basically, and this is basically the pre-prosecution stage. Post prosecution, if you are in court and if you are charged with tampering or destroying the evidence, then the onus firstly will be firstly to prove that that the documents that the chartered accountant have, what has exactly happened, and somewhere the onus will be on the chartered accountant to prove that due care and precaution was taken and the circumstances under which he could not produce that documents.
Ishaan, just
Okay,
can I add a point to
Yeah.
what Mr. Kartik said?
Yes.
See, fundamentally, the chartered accountant has to be also careful in the context of his own responsibility and obligations and duties under the Chartered Accounts Act and the ICA guidelines. So there have been instances where disciplinary committee has taken or initiated action for errors in tax audit reports. And there have been number of instances where the trail of audit have not been maintained and action has been taken. So from a professional perspective, that there is definitely a trail that requires to be maintained, and it would be difficult to say that, you know, if you play the role of an auditor, that I don't have the trail, or I don't have that kind of information. But if there are also instances where the client takes the easy route by saying that I don't know anything, I've given everything to my CA, only my CA knows everything. That is his escape route, so that the entire questions fall on the professional. So that there have been instances where the client is probably guilty, but he passes on the nuisance to the professional. So it has to be very carefully dealt with.
In fact, there was a matter, I think some 3 months back before in Bombay High Court, and the lawyer, the petition was that I don't want to attend the summons, I want my CA to go, and that it is an infringement of my legal rights that my CA is not being allowed. The judge said, okay, send the CA. He gave him an order, and if there are any untoward documents, he will face the client will face the consequence. Everyone who was sitting in the back, we were like, who is this CA who wants to attend in place
Why
of
would
the
you want
client?
to take the blame unnecessarily?
Perhaps Gurugram had not happened then, so he must be thinking, "Mere ko kuch nahi hoga." So the next question is to you, Mr. Vaitheeswaran. What is, and because very frankly, there is a great curiosity, what is this anticipatory bail? And generally, how much time does it take to secure? And I'll ask Mr. Kartik also, because most of us from Bombay, he will be able to explain first Mr. Vaitheeswaran, then Mr. Kartik. Because I am told in Bombay, ABA takes a very, very long time. To the extent people ask whether we should go for an ABA, firstly. So, sir, first to you, what is an anticipatory bail application and how much time does it take to secure an ABA?
See, obviously, when the inquiry has started regarding an offence, and typically these inquiries, despite what the board says about how friendly it is and how instructions are given that you may have it, if you can pay the taxes with roses and all that, we know how in most cases the inquiry is not that friendly. So there is always a threat that a person who's been subject matter of investigation or inquiry gets a feeling that there is an arrest which is imminent, and sometimes it is subtly conveyed, and in most cases it's directly conveyed, saying that you can be arrested, and initial action can be taken because we have all the powers conferred under the law. Therefore, the person immediately panics, and then there are two consequences. One, if it is a case of, that person is answerable to a board, or is not comfortable in spending hours and hours at the inquiry office, and somehow or other they make the money out and pay off the taxes to reduce the impact. But there are others who might say that, look, this tax is not due. I fall in the bona fide category. This ITC is genuine. The person who has made a statement against me is generally made a statement. I would like to cross-examine him. I have all those rights. And then based on that, he talks to professionals, and somebody suggests that why don't you take a anticipatory bail? And that's how it starts. So typically, the anticipatory bail would come into a situation where the offense is identified as a serious offense, as a cognizable offense, and therefore non-bailable. And then you may have to approach either the Sessions Court or the High Court in some cases for anticipatory bail. Now, practically, of course, Mr. Kartik will have much more experience in the criminal courts as to what are the criteria which the court looks at. But we have seen a number of cases in these matters, and of course, he's now been appointed as a prosecutor of the central government. I don't know how he's going to be in court, but the general prosecution lawyers who are friends of mine, they will always convince the court that huge money is involved, lot of money stake is involved, state's revenues will be completely lost if this person is out on bail, etc. And then inevitably that will be the reason for rejection of the anticipatory bail. So it does come up fast in this part of the country. It doesn't take that much of time, as you talked about. But anticipatory bail is somewhere they're not going to go into your merits. They're not going to go into whether your invoice is valid or not, or whether your correct availment is correct, your business test is met or not. The courts are not going to spend time much on that. So the quantum of the dispute will have a major role, and how the prosecution builds the case in terms of your role. The role, if they're able to identify that you've been a manipulator or you've done all kinds of shell transactions, there are 50, 60 companies involved in something like that, then the courts would not be so easy or comfortable to grant an anticipatory bail. But if they feel that the circumstances do warrant, there are a number of instances where courts have stepped in and granted the anticipatory bail, because it is definitely a significant remedy which is due. I will just quote a few decisions which will be relevant for members in this context, and then we can move on. You can read up on it later on. For good knowledge on the subject, one can read the decision of the Supreme Court of the case of Siddharam Satlingappa, that is 2011 1 SCC 694, that gives significant observations on 438. And then the recent observation of the Supreme Court in Mr. P. Chidambaram's matter, where he sought anticipatory bail, and the court did observe that at the stage of granting bail, an elaborate examination of evidence and detailed reasons touching upon the merits of the case which may prejudice the accused should be avoided. And of course, the general rule that grant of bail is a rule and refusal is exception. See, all that is good principles, case laws we can quote and things like that. But in an actual case, when you move for AB, you also are risking that if AB is granted, fine. If AB is rejected, then the authorities may be compelled to arrest you because AB has been rejected. So you need to be very, very careful on this. Your view, Mr. Kartik.
So basically, sir has covered a lot, but I'll add to that even there is a gray area with respect to anticipatory bail. There is a basically view of Telangana High Court which says that as there is no FIR that is being lodged with respect to GST offences, there cannot be a anticipatory bail application that will not be maintainable. However, there are divergent views taken by different high courts saying that it will be maintainable. Now it is up to the Supreme Court. Now this issue is basically pending whether anticipatory bail will be maintainable or not. Having said that,
Bombay, most of the members are from Bombay. What is Bombay High Court or the Bombay Sessions Court saying? Maintainable or not?
Yes. So with respect to Bombay High Court has not specifically dealt with issue of maintainability, but Bombay High Court has been hearing the cases on merits. So in Bombay, it is not happening that only by saying that anticipatory bail application is not maintainable, it is rejected. They are hearing on merits and they are allowing or not allowing the application. Secondly, with respect to saying that the course of time it takes, this answer basically I can't give honestly, because it all depends upon the case to case, because this being a little complicated issue, because most of the arrest that has been taking place is before adjudication, before assessment. So it is very difficult for the courts or even for the accused to put before the court the real circumstances or to justify his actions. So court usually goes on the report or the say that is filed by the prosecution, where it is usually where the whole it is almost like a show cause notice that is issued under 73 and so on. So it becomes really difficult for even the for the courts to basically decide whether to grant or not. However, there is basically, if, may I add this also, that anticipatory bail, it's not like if there is a summons issued under 70, there will be going to be a direct arrest. It's always that an opportunity is given by the officers also, so that you can come and cooperate with the investigation. If you have cooperated with the inquiry, if you have produced all the documents, it is basically the courts which decide in favor of that accused if the cooperation is seen. It can't be that each and every case, just because there is an offense, there is a summons, you are going to get the AV is going to get rejected. Secondly, with respect to Telangana High Court, may I also add this? Telangana High Court has taken a view, though anticipatory bail application will not be maintainable, a writ petition under 226 can be said to be maintainable for anticipatory bail. Now, this is some gray area, which I think, according to me, if I am asked personally, I don't think would be a good law, because there are judgments of Supreme Court which says that irrespective of whether FIR is lodged or not, there should be only apprehension of arrest. If you are having apprehension of arrest that I may be arrested, irrespective of there being an FIR, the anticipatory bail application will be maintainable.
Correct.
We will record what you are saying and cite it against you. Now
So
that you are a public prosecutor.
I understand the restrictions that I have right now.
It's okay. Now, question number 6 is to Kartik Garg. Maybe Mr. Vaitheeswaran can also answer it afterwards, because it has some tax implications also which are very peculiar. A has issued an invoice to B. A is the seller, B is the purchaser for sale of goods. Value is rupees 100 and GST is rupees 18. Now A, who is the seller, has collected the GST from B and deposited with the government. But there are no goods. There are no goods in existence. Now, can you say that A has not retained the benefits arising out of the offense, as we discussed under section 132(1), retain the benefits?
So basically, to understand this, let us see the offenses. If we see this may fall under 132 B or C, which is issue of invoice without supply of goods or services. But the main ingredient for that is that there should be availment of ITC or wrongful refund. In the absence of availment of ITC, wrongful refund, or misuse of that, or going against provision of law, if ITC is availed, then and there only the provisions offenses under section 132 can be made out. As your question goes, it only says that A has collected GST of 80 of rupees 18 and deposited with the government. Now, if there is no question of availment of ITC or wrongful availment of ITC, there cannot be an offense. Basically, there has to be a wrongful availment of refund or ITC, then only it will fall under B or C. If there is, then it will fall. And benefit arising out of, as I said earlier, that causes to commit and benefit arising thereof should be together. So even if suppose we go pre-amendment, we see the pre-amendment scenario. Still, if we take this example, along with along with that, if in this example, if ITC is wrongly availed, then this will fall under 132B and C, section 132B and C. And if there is no availment of ITC, there is no question of any offense then.
Very well. Mr. Vaitheeswaran, you have any views on this?
Yeah, that seems to be a logical thought process, because interestingly, this entire fake invoice racket has opened up all these questions. And if you go by the mastermind theory of what the council referred to, and drivers and cooks have become GST suppliers and have raised invoices and have registered and paid tax, what benefit did they retain? So they've collected the tax from somebody and they've paid tax to the government, and you cannot say that they retained any benefits. Of course, the nefarious methodology through which this transaction happens could be different, and what is the scope of the benefits can again come back to haunt the courts. Take as I referred to in anti-profiteering, the anti-profiteering, some of the decisions of the NAPA have gone on to even pre-GST credits, compared pre-GST credits with current GST credits, and said you might have got this benefit because you procured in the system and you got the ITC, and that benefit is, since you have not passed on, we are taking action against you. So the scope of benefits can be something which can be interpreted. But I would largely agree with Mr. Kartik, because the first supplier in the chain has not retained any benefits. Now this opens up a larger question, and the larger question is this: if offense is well established, that 132(1) is applicable, there is paper invoice that is raised, no goods have been supplied, and prosecution has been launched, I mean the provisions have been applied against A as well as B, and then A is let off, but B is found to have retained the benefits and therefore action is taken against B. In all this, what happens? What gets established? What gets established that there is no supply. So if there is no supply, what happens to the tax which was paid by A to government? Can the government retain that money in the name of GST?
That is the next question.
Oh, I'm okay. I'll take the question as if I move to the next question.
Now, in fact, I also wanted to ask you in the next question that if ultimately there is no supply, all these prosecution provisions, etc., I would believe there were many judgments which said that, for example, sales tax entry 54 list 2, the authority to enact penalty provisions, etc., is ultimately to recover the tax, etc. Therefore, it is incidental to the legislative entry. Now, ultimately, if there is no supply, all you are doing is to punish these people who are engaging in this activity, but with no revenue loss, no tax consequence, etc. Does that even fall within their authority to enact these laws? Parliament may have that authority under entry 97 residuary risk, but the state governments, ultimately, if they don't have that any tax implication, then can it be said to be incidental to the power under 246A?
That would remain an open question, because the fundamentally what has happened is that the menace of fake invoice has been such that the action has also been quite harsh, that everybody in the chain seems to have been visited some kind of action. So I would look at it very clearly. If somebody gets a benefit, the person who gets the benefit is the person who uses this false ITC to set off a genuine GST liability, or uses this false ITC by encashing it as a refund. Now that is clearly loss of revenue to the state exchequer in some form. So that is the person who is actually the culprit to take some benefit out of the entire transaction. The rest of the persons who have raised invoices and paid GST, they have paid to the account of the government. And if the government has collected the tax, then they may have to justify this under Article 265. So it must be a levy and collection authorized by law. And if you look at Article 246, say, where is the supply? And the fact that there is no supply is demonstrated by the findings under 132.
Yes.
So it is going to be very tricky, because all these are at very early stages, And when it goes up and the findings are given saying that there is no underlying supply, then larger question comes up as to what happens to GST paid by the time that GST would have been distributed, because it goes through that pool and stuff like that, and it has gone through different states and stuff like that. So it is not going to be easy to determine a question as to how it is. Now, probably some courts might take a view that the government should not have retained this. A can apply for refund, but A will not qualify for refund. Money has to go to welfare fund. That could be probably some of the decisions that may ultimately come.
Limitation is also an issue, because the limitation for assessment is so large, but your refund limitation is very small. So that basically covers question 7 also. I'll come directly to question 8, which is for
Now,
Mr. Garg.
just to complete that, there was some research I did for question number 7, and I found a very old
Yes,
decision in the excise law. The citation is Mahesh Kumar Goel, 177 ELT 561. Now, in that, the tribunal observes like this: the revenue says that the transaction of sales incorporated in sale invoice of appellants are without transaction of goods, because no goods were brought or transported by him to his godown. It becomes essential for revenue to bring on record the evidence of driver or owners of vehicle, which, as mentioned in the undisputed invoice of sale, etc., that transported the goods. Failure to do so leads to the inevitable inference that the state of affairs mentioned in such invoices regarding transportation of goods cannot be doubted.
Thank you, sir.
Yeah.
With respect to the next question is really, there is a monetary limit in section 132(1) and 2. That monetary limit is also then for your arrest. That 132(1) and 2 is limit of 500 lakh rupees and 200 lakh rupees. Now the question really is, CGST and SGST are different enactments. The offences under them are also actually different enactments. For the same transaction, आपका तो क्या 9% जो भी होता है credit 9% tax भरना है. But in law, whether these are therefore separate offences or it is really the same offence, or it is will you club them to reach that 200 lakhs or 500 lakhs, or they are different? They have to be cumulatively, they have to be distinctly seen. In fact, that in the morning when I was discussing this with Mr. Kartik, a further question arose कि अगर ये समझो अलग है, and there is in a case where in under both 500 lakhs, for example, there are under SGST 500 lakhs, CGST 500 lakhs. So the sentence will also run parallelly or consecutively. CGST का जो भी imprisonment with SGST वाला. Over to you, Mr. Kartik.
There is no specific answer to this. It is open to judicial interpretation. Let me say this. Now, as you said, so there is a part 50% that goes to central government, 50% that goes to state government. Now in this,
but SGST are distinct totally under different acts.
correct. That is
IGST is collected by center, 52 state, 50 state. But GST and SGST are entirely different acts, are different collections, though it may be looking copy paste of each other.
correct. So that is the thing. Basically, as you already said, there can be two scenarios. Suppose we club it together. If we club it together, take it for example, if we see the prosecution and arrest can take place only when the ITC availed or some like that, if it's more than 5 crores. Suppose I have availed 3 crores from CGST, 3 crores from central GST. If that is clubbed together, then I'll be liable for arrest. And if it is taken distinctly, then I'll not be liable for arrest. Now there can be also a situation where there are two prosecutions under CGST and SGST, and I'm convicted under both. Now for one cause of action. Now the thing is, though there may be two different acts, but the cause of action is the same. And that cause of action, though GST is paid to two different governments, state and central government, but whole cause of action, which is an offense, is the same. There cannot be two prosecution or two punishment under two different two different prosecutions for the same cause of action. So that is some area which has to be clarified by the court. But then again, clubbing both together will again be a problematic because both the acts are different. So this is something open again to judicial interpretation, how the courts are going to look into that. And then the another question about different assessment years, whether offenses spread out over different assessment years be clubbed together for the purpose of monetary limit. Now to answer that, there can be a continuing offense which form part of same cause of action, which may spread out to 1 year, 2 year, or 3 year. Now for the purpose of adjudication, the assessment can be done as per assessment year, but for the purpose of prosecution, it is not necessary that it has to go by assessment year, and two assessment years cannot be clubbed together. There has to be a period when this offense has been committed. That period can range from 1 year or 2 years. It is irrespective of what the assessment year is. So yes, that can be clubbed together.
I'll add one more twist to what Kartik said, and I would like this view. What happens if prosecutions are launched simultaneously and one of them is dropped?
One of them is dropped, then again. So basically, even if we see, there can be assessment proceedings, adjudication that is started and that is dropped for some reason. If it is dropped on merit, saying that no, the whatever happened is proper and there was no wrongful availment of the act, so no doubt prosecution will go. But if assessment proceedings or any such thing is dropped for some other reason, we'll have to see the reason for which it has been dropped, and then only we can say. Now there is also a judgment in income tax which says if there is what you say, adjudication. Yes, so that will apply again.
Now, these are very interesting questions because the quantum of the arithmetical quantum can take you elsewhere. But what is the purpose? Because if you look at simultaneous levy, same charging section, same kind of transaction, same cause of action, and things like that, one will have to see it very carefully as to how courts would also read into these things.
Correct. Even there is one more thing. Basically, for the chartered accountants, they can at the most, if they are doing within their what their functions are as a chartered accountant, they can be charged under abatement. Now there is no separate punishment for abatement. The Act clause 1(2) says that it only the punishment is as per the monetary limits. So clause 1 says that if the amount is between 5 crores, more than 5 crores, then the punishment will be 5 years. If it is between 5 crores to 2 crores, then there will be a different punishment. So if we see that, so for abatement and for the main offenses, the punishment has been specified the same. The punishment for abatement with respect to the three provisions, that is K, J, K, H, I, is different. However, abatement punishment with respect to A, B, C, D, which are the main offenses, if there is abatement to that, there is no separate punishment that is specified. So it will mean that for abatement and for the main offense, the punishment is the same.
Or no provision exists.
No, it can't be said no provision exists. But we have to go by
Ishaan, this is a very interesting point which Mr. Kartik has brought across, because if you see 1, 2, 3, 4 clauses, that means which talks about the quantum of punishment. Clause 4 is the one which talks about abets the commission of an offence specified in clause of G and J. And clause of G and J are falsification of records, obstructing officer from discharging his duties, and J talks about tampering or destroying material evidence and documents.
There is no punishment at all.
No, it can't be said there is no punishment. We'll have to read 1. No. So we'll have to read 1. So it will be read as in cases where the amount of tax evaded or the amount of input tax wrongly availed so and so, with imprisonment for a term which may extend to 5 years. Now this 5 years imprisonment is with respect to all the offenses that are specified from A to L, basically, where there are specific. So with respect to F, G, and J, and abatement with respect to F, G, and J, there is a separate punishment. So this will not come in the provision Roman 1, small 1. So for that purpose, this punishment that is specified in 1 and 2.
Isn't for a specific provision for only abatement? So is it not excluded from 1, 2, and 3 abatement? I mean,
basically 1 includes everything, including the abatement and the main offense as well.
okay.
Interesting times. In fact, L also talks
I
about
don't know
items.
criminal law, so I don't know. You only know. And it is interesting, no doubt. These are, as I said, questions for whom answers will come probably after 20 years. First, all the high courts will create chaos by giving different interpretations. Question number 9 is for Mr. Vaitheeswaran. There is a lot of curiosity. What is this cognizable, non-cognizable, bailable, and non-bailable? Sir, if you can briefly explain. We are, I think, now at 6:40. So we probably have to run through the rest of the questions a bit faster. If you could just explain these 4 terms, sir.
Yeah, see, my knowledge of criminal law is to the relevance that is required for my practice in terms of clients' needs at points of time, and I'm not a person who's coming out of magistrate courts on a daily basis. But cognizable would see, from a society takes cognizance of certain offense differently. So it shocks the conscience, so to say. A murder would shock the conscience, a dacoity would shock the conscience. So when you say cognizable, then the society has to ensure that those offenses don't happen and it is arrested immediately. And therefore, the police officer is conferred significant powers. Therefore, he can arrest without a warrant if it's a case of cognizable offense. But if it's a case of a non-cognizable offense, then it is identified as a less serious in nature, where the officer has no right to arrest without a warrant. Now, for some reason, in tax matters, and specifically it started with GST and initially with service tax and then went on to GST certain changes, the specific offenses are declared as cognizable, which means the bail becomes complicated and the arrest provisions also becomes much more easier. Now, what was the need for that is something which I've always asked myself, and whether that kind of stringent provisions were required. If we take Companies Act, the kind of initial approach was to criminalize everything. And then after one round of pressure across from 2013 when the act came, and subsequently now last 2 years or last 1 year, you have this new trend of decriminalizing the entire Companies Act. So the entire exercise of decriminalization has happened in a big time, and many offenses have been knocked off from the scope of criminal action. And if you look at FERA versus FEMA, again the same impact. So FERA was a very powerful legislation where prosecution was very significant, but FEMA is more of a regulatory mechanism where penalty is the focus. So in GST, when you have provisions which talk about interest at 18%, when you talk about penalty which is equivalent to the tax amount, when you talk about significant late fees, etc., and confiscation, attachment, pre-attachment, etc., when there are so much of powers available to legitimately recover the taxes due for the government, should the sections declare certain offenses as cognizable is a bigger question. So by declaring it as cognizable, then the bail has become the big issue, and all those things have all come into play. Arrest has become easier. My humble view is that we need to relook at 132 itself and need not be focused on declaring offenses as cognizable, at least revenue matters and tax matters.
There was, in fact, sir, now that you mentioned, I don't do criminal matters, just one matter. Someone had said, ki, aa jao, Companies Act wala prosecution hai, kar lo. And that court, some 20 matters, 19 matters were some dog ran over, some cat was injured, etc. 20th was and what a silly matter, some board report not filed in time. That prosecution has been going on for the past 7 years. This trial is going on for the past many years. We believe someday we will have to look at all of this and perhaps rationalize it.
Correct.
Mr. Kartik, you have anything to add to this?
So basically, if we go by the term, cognizable offense basically means where a police can arrest without warrant. Non-cognizable is when they can't arrest without warrant, they require the permission of the magistrate of the court. Bailable means bail is a matter of right. So the police or the proper officer is not going to arrest you directly. If he comes to arrest, it will only be a formal arrest. Bail will be granted immediately. Non-bailable offense, he'll arrest a person and take him before the magistrate, and then magistrate will decide upon the bail application. Now, if we go by the act, there is provision section 132(5), which specifies what are the offenses which are cognizable and non-bailable. Without going into the provision, let me put it very simply. If there is an offense under 132(1) A, B, C, and D, which is with respect to where there is a supply of good without invoice, or whether it is invoice without supply of goods, wrongful availment of ITC with respect to when there is no supply of goods, and then when tax is collected and not paid to the government within the specified time, that is 3 months, plus with that the amount involved should be more than 5 crores. If the amount involved is more than 5 crores, then only the offense will be cognizable and non-bailable. Rest of the offenses, so it has been divided into 3 parts. First part is offenses where the amount is less than 2 crores. Second is 2 crores to 5 crores, and third is more than 5 crores. If it is more than 5 crores, then it is cognizable and non-bailable. The proper officer will have a right to arrest you. He will produce before magistrate, and then bail application will be decided. The second category is between 2 crore to 5 crore. That is bailable offenses. He will not, basically a person can't be put behind bar. He will have a right to bail. Interestingly, if the amount is less than 2 crores, there is no punishment specified. So if there is no punishment specified, there can't be prosecution. There can be only penalty provisions. That is what my reading is, because there is no punishment at all. If we see clause 2, it says that in case where the amount of tax evaded and so for exceeds 200 lakh rupees but does not exceed 500 lakh rupees, imprisonment is 3 years. And then yes, there is one more category of 1 crore to 2 crores, whereas punishment is 1 year. But when the amount is less than 1 crore, there is no punishment specified. When there is no punishment specified, prosecution cannot take place. So if it is less than 1 crore, there will be penalty provision. If there is more, the amount is more than 5 crores, then it is cognizable and non-bailable. So that anticipatory bail and everything will apply only when the amount is more than 5 crores.
But then therefore, as I think you only opined earlier and Mr. Vaitheeswaran was saying, these chartered accountants, most of them will fall within this abatement clause, which is 132(1)L. Correct.
Yes.
132(1)L does not fall in 132(5).
No, it doesn't fall.
Gurugram CS. Yeah.
So I would not like to comment on what happened in Gurugram.
Non-cognizable and bailable.
So Ishaan, you're putting him into trouble. He cannot interpret 132(1)L versus 132(1). I think you should free him from the question.
So let me give an example. So there can't be prosecution for abatement without a main offense. So if there is a prosecution or enquiry, there has to be offense under the main offense, that is 132(1) A, B, C, or D. With that, there will be abatement. There can't be abatement without the main offense, basically. So when there is abatement clause with that, the law provides that if I have committed A, B, C, or D with 5 crores, then only I can be arrested. There is no arrest provision so far as this abatement is concerned. So basically only for abatement, if I am charged only for abatement, there can't be arrest.
Basically for chartered accountants, this is something to be thought about.
This is strict reading of the act, basically.
Now, next question is for Mr. Garg only. This 69(3)B, again, light has gone. Just 1 minute.
Reasons to believe.
69(3)B. Sorry. 69(3)B. Section 69(3)B says in case of non-cognizable and bailable offense, Deputy Commissioner or Assistant Commissioner shall, for the purpose of releasing an arrested person on bail or otherwise, have the same powers and subject to the same provisions as an officer in charge of a police station. Just explain to us what this is really, because
Basically,
this is all
as
mystical for us.
no, so it's very simple. Basically, there are two categories. One is bailable and one is non-bailable. If the offenses is bailable, so 69(3)(b) deals with when the offense is non-cognizable and bailable. When it is a bailable offense, there if we take a normal offense under IPC or something, so the police officer can't arrest directly. What he can do is he will have to first, if the person is ready to furnish bail, he will have to show formal arrest and admit him on bail right away. He can't be put in prison. The same power has been granted to assistant commissioner and deputy commissioner. So suppose there is a bailable offense under GST Act, what he can do is at the most ask the person to furnish bail bonds. Now what is bail bonds? Bail bonds are basically personal bonds saying that I will in future, if required, attend the courts. It is in a form of undertaking. Sometimes even the surety will be required. Surety is one independent individual who is not accused of offense. He will have to give an undertaking that I take guarantee of this person that he will not abscond, and if he absconds, then I will pay the pre-decided amount. That is what it is. So basically there will be no arrest. There will be only a person will have to furnish the bail bond. And basically nowadays they take you directly to the court, and this happens before the magistrate. But these officers also have power to admit you on bail bonds.
So they have the power, not the obligation, is what you're saying? In case of non-cognizable and bailable, I'm sorry because we just don't know, I want a clarification. In case of non-cognizable and bailable, he's not obliged to release you immediately. He can still take you to court.
No, if I'm ready to furnish bail, he will have to release me. He can't restrict my movements. Basically, he can ask me to come to the court.
Okay.
He can no doubt summon me.
Yes.
Not, yeah.
Next question is also for you, Mr. Garg. I think by mistake, otherwise alternate questions were to or both the panelists. By mistake, this has happened. Anyways, section 69 requires reasons to believe before an arrest can be made. Is it a requirement of law to furnish such reasons to believe before or immediately after the arrest is the first question. If it is found that the reasons to believe are either non-existent or extraneous, or what is the proper forum to challenge the same to get expeditious relief? Because as far as search and seizure is concerned, I think under taxation the law is that even if there is an illegal search, etc., that does not vitiate that reasons to believe, etc. But in case of arrest, does it vitiate the arrest if the reasons to believe ultimately turn out to be non-existent, etc.?
I'll start with
totally
this.
irrelevant.
Yes, the very first question, whether there is obligation on the part of the person who is arresting to give the reasons to believe to the accused who is being arrested, answer is no. There are judgments specifically which says that in an arrest memo or while making arrest, there is no need to give reasons to believe to the accused. Second, the question arises whether the arrest memo or whether the remand report. So when a person is arrested, taken to the magistrate, they furnish a remand report where they give reasons why he's arrested. But now this reasons to believe, whether that has to come under the should be recorded in writing, the answer is again no. There are judgments of Telangana High Court and different high courts on this, because the term that is used is reason to believe, not reasons to be recorded in writing. So this term has been interpreted to be like as such that what is required is there should be such reasons to believe in the files of the officer, which can be assessed, which can be seen only by the court. So that reason to believe has to be present in the files of the officer who is making arrest. Now the question arises whether the accused has right to see that reasons to believe or not. He has no right at the time of inquiry, because as per criminal jurisprudence, at the time of investigation, accused have no right to be heard. Basically, It is only when his liberty, there is a question of liberty, when he is arrested or anticipatory bail is there, the reasons has to be given by the prosecution, or else with otherwise with respect to investigation, he has no right to be heard at the stage of investigation. It is only at the stage of trial. So going by that, even at the time, the reason to believe, there is no requirement to be given it to the accused. What were the reasons for which arrest is made? Now the question arises that in such situation, the accused is basically handicapped. If he's arrested, whether his arrest is proper or not, who will assess that? So the answer would be, once a person is arrested, he's taken before the magistrate. Now, magistrate basically is not a postman. He has to always apply his mind whether the arrest is proper or not. When a person is produced before the magistrate, magistrate will look into the files of the arresting authority. He will see whether there are reasons to believe or not. Then only he will authorize further detention of the person, or else he can direct him to be released on bail. Now, with respect to the question, other part of the question, that what will be the proper forum? Now, obviously, a person will not know what are the reasons to believe, what are the reasons for which he has been arrested. But from the circumstances which are there in the case, he can surely tell the court that there cannot be any reasons for which I can be arrested. On that ground, he can very much challenge his arrest first before the magistrate, or else even he can even go before the High Court under writ jurisdiction and say my arrest is illegal because there was no reason to believe at all. And there have been instances where the court has actually basically entertained such petition and have looked into the files of the officer and found out there were no reasons, and that was basically the person was released on bail. So it's not that the person has no the arrestee can't go anywhere. First forum is for the magistrate, who has the access of the files of the officer. Second, if required, he can even go to High Court, but that High Court exercises this power only in exceptional cases where it is apparent on face of record that there is no reasons to believe and the arrest is illegal.
But so therefore, at least the magistrate can give us a copy of the file, correct? Or he does not give that also?
That can be seen only by the magistrate. Accused has no right.
Therefore, how will we know then what has happened?
That is what the thing is. We can't know basically what is written in the file. We can only say that from the circumstances, there could not have been any reason for my arrest.
Oh, that's a significant handicap. Anyways, law is what it is now. What to do? Now the next question is to Mr. Vaitheeswaran. Is a petition under section 482 CRPC maintainable in case of GST prosecutions, and what are the general criteria of maintainability? Now, from my limited knowledge of criminal, and I have always felt that 482 CRPC is like a writ petition only, just filed under a specific statute. Now, if you can just explain if it applies to GST prosecutions.
See, 482, if you read the way it is structured, it gives powers to the High Court, where inherent powers are available to make any orders, to give effect to any order under this code, or to prevent abuse of the process of any court, or otherwise secure the ends of justice. So just like Article 226, if a person apprehends that the entire thing is a witch hunt, or the entire thing is a kind of a malicious action, or there is some other reason for all this action happening and he is on the right side of law, and he's not able to seek any kind of remedy in the courts which are dealing with it in the form of magistrate courts or things like that, as you said, he has no access, etc., then he can try a petition under 482 to seek to quash the entire thing. And there have been instances where the court has interfered. There have been instances where the court has refused to interfere, saying that you face the music accordingly as and when it comes. Or there have been cases where courts have given directions to go about it. But it all depends upon you should be able to invoke the court's jurisdiction, convince the court that you're on the right side, and have some degree of doubt that can be thrown on the entire action that is taken. And if that happens, then you are likely to get some relief. But if it otherwise typically it depends upon each sitting judge under the portfolio of that point of time. There could be persons who would simply say that the amount is huge, therefore the court will not even interfere. So I don't know what to say as jurisprudence in this, but if you're on the right side, nothing wrong in knocking the doors.
Mr. Kartik, you have any specific view on this?
So basically, if we see
Because I which say that even if there is a slight 138 matters, slightest dispute on facts, 482 is not maintainable. If you admit that the whole, assuming that the whole charge sheet or whatever is true, still if no offense is made out, then only 482 is made. That is what I vaguely recall.
so
Is that
basically inherent powers. High Court in inherent powers is not going to interfere in a usual course of work of the lower courts, basically, even the investigation. Now, if we see 482, when it can be invoked, there are only 2 to 3 categories. Is when such orders are necessary to give effect to any order under that code. Second is to prevent abuse of process of any court or to secure the ends of justice. We have so the case has to be under these 3 categories, and this requires basically quite a apparent case on record on face of it to convince the court to exercise inherent powers. And for GST Act, let me add this also. With 482, it will always be useful to invoke 226 or 227 also, because if we see 482 is basically is for to make such order as will be necessary to give effect to any order under the code of CRPC. Now this GST is a special law. Most of the provisions override the provisions of CRPC also. So invoking only 482 may not be sufficient. One has to also go under 226 or 227.
okay? Then the next question is to Mr. Vaitheeswaran. Can the office or residence of a CA be raided by the department in connection with the suspected offense by his client?
See, when an assessee is under investigation and the department is armed with all kinds of data and information about the nature of offense and what has actually been done, then the department will also be privy to who are all the parties involved. And to a large extent, if they're able to identify that there is a mastermind who's actually a professional or something, then when they go with the search warrant, they would ensure that that particular person is also covered. Now that is a different story. Then it is quite possible to do what is contemplated in the question. But merely because an assessee is at fault and there is some investigation or inquiry going on to exactly establish what is the violation, exactly establish whether the bona fides of the credit is to be tested or not. Just because the assessee is under investigation and the assessee has been raided, that does not give any right for the authorities to jump from there straight to the office of the CA or the house of the CA. In fact, even if you recall, some more than a year ago or 2 years ago, the Gujarat High Court came down heavily on some of the action taken by the tax department by staying in the house and residence of a person and disturbing their normal movement and things like that. But whether it stopped or not is, we don't know. We need to see the ground level. But to a large extent, officers are also quite aware of the law. It is not as if they just go on exercise of raiding everybody around. They are also quite competent and they are well seasoned. They have tons of experience, so they know which case to go and which case not to go. But I always have to put this in perspective. I have this theory. I think I can, with more than 3 decades of experience, I can stick out my neck and say this. Where does the problem start? The problem starts in fixing targets. Somebody at the top fixes the targets for each zone, each officer, each collection. So much of tax has to be collected. So when that kind of pressure happens from somewhere and the country is not growing that level to give that much of revenue, or the economy is not growing that level to get that revenue, then these kind of things do happen. But it's quite unfortunate, but we need to stem the problem somewhere else.
Okay, sir.
It may only add one thing to this. I'm sorry.
Yes, yes.
Yeah. So if may I only add one thing to this, if we go strictly by the Act, first, section 67 with respect to power of inspection, search and seizure is very clear. 67(1) clearly says that a person, the proper officer can be authorized by joint commissioner only to inspect place of business of taxable person or person engaged in the business of transportation of goods, owner or operator of warehouse or godown, or any other such places. So it has to be read in its conjunction, so completely. So this doesn't include chartered accountant. When can a chartered accountant or any other person not related to this category can be raided is given in subsection 2, wherein it says that they have reason to believe that the documents or any other goods have been secreted. So there has to be first, there cannot be direct raid to the office of chartered accountant. There is no question. Only when there is a subjective satisfaction and reason to believe that documents or papers have been secreted in a chartered accountant's office, then only they can raid. Otherwise they cannot. So law is basically very clear on that.
The
So
next question is,
just
yes,
for the
yes,
benefit of members, the scope of the word secreted, please read 13 ELT 1365.
thank you. The problem with this search and seizure matters is that while the search is going on, maybe for 1 or 2 days, no court interferes. That is the problem. Even illegal evidence collected is admissible evidence. That is the biggest problem. So no search, I think, takes over 7 days or 8 days. They'll come one day. You won't even gonna get circulation, at least in this court. Well, there is a general tendency not to interfere at investigation stage. If your hands are clean, why should we interfere? The next question is to Mr. Garg. Can department demand production of records maintained by a CA while giving consultancy to his client? Are such records protected by any privilege? Are working papers and other records maintained in the course of audit privilege? Now, I'll just give a brief background. In audit, a chartered accountant is supposed to be very honest, basically. He's supposed to put the truth of the matter on. But when we are giving consultancy or we are representing someone, I don't think there is any duty to be unnecessarily honest to the department. We have to ultimately defend our client. I'm an advocate now. But even as a chartered accountant, if I am going and appearing before an authority, I'm not supposed to blabber out everything that I know. I have to defend him just like a lawyer would. So while in course of audit, he has that duty. In course of representation, I'm not sure he has. But what happens to the papers? That is the biggest question. I believe lawyers, 2-3 lawyers' offices were also raided for some other offenses, not just GST, PMLA, etc., etc. So this trend has now started.
No, so basically, with respect to demand of production of records, the primary duty is never on a chartered accountant. Let us take it this way. During an inquiry, what documents can a proper officer may require? It can be because most of the documents that are now are being uploaded on the website itself. It can be ledger account, it can be basically books of account, then lorry receipt, all such things. These documents are primarily always with the client himself. He can't just push away his responsibility saying it is with the chartered accountant. So the primary duty is with the person himself, and the chartered accountant is only a custodian. So when a proper officer issues summons for production of document, it has to be to the client himself. Now coming to the question of privilege, now that privilege that is there with the advocates is not there with the chartered accountants. And there are now, let us see, look this in 2 stages. First stage is the chartered accountant who is involved with the client when the offense is committed, basically when the offense is committed by the
Kartik, first explain the concept of privilege. Some people may not be knowing.
So privilege communication is this. So section 126 of Indian Evidence Act and other sections say that when there is a communication by any client to attorney, advocate who may defend him in the court, such communication is privileged. So suppose my client tomorrow comes to my office and say that you have to defend me, I have committed a theft or murder. Now I can't be made that the court or investigating officer cannot say that you depose against this person because he has admitted his crime before you. That communication by client to his advocate is privileged. One cannot make an advocate, or there is no obligation on the advocate to depose against his own client, which is made in the course of the communication that is made in the course of such consultancy. Now, so far as chartered accountants are concerned, there is no such privilege that is there to the chartered accountants. It is restricted only to those who represent a client before the court, and largely only the advocates are covered. So far as records that are maintained, so it can't be said that the records that are kept of the client are the privileged records. So if the summons comes that the client has said these records are with you, and because chartered accountant can only be said to be the custodian of the records, custodian of the papers that is of the client, so that will have to be produced, and the primary duty is basically with the client only.
Mr. Garg, just add to one point. This is 126 of the Indian Evidence Act. There is no way it will apply to a chartered accountant because the way it is structured, you can't apply that privilege on professional communication to protect a CA. But interestingly, there is one decision of the Kerala High Court in the case of ICAI versus Money Abraham, AAR 2000 Kerala 212, where the Kerala High Court decided on the disciplinary action taken against the CA, where the court stressed on the importance of confidentiality of professional communication by quoting the existence of 126 of Evidence Act. Even though they never gave a finding that 126 will apply to CAs, they applied that analogy of 126 and said that this would apply. And one would also do to read the decision of the SR Batley Boy versus Department of Investigation 315 ITR 137, where it so happened that the tax department seized the laptops of the auditors while doing an audit of the client. And the auditors agreed to provide all the data relevant to that client, but they were concerned by the fact that all other data was also sitting in the laptop, all other client data, which is irrelevant as far as this raid is concerned. So the Delhi High Court agreed to the argument that such unrestricted access would amount to breach of professional ethics on the part of the auditor, and therefore they gave some relief in the context of that. So it's very interesting because nowadays in IT raids, they take the laptop of the professional, who's the chartered accountant or the auditor, etc., and that would contain so much of other data, and you cannot go on a fishing expedition and then find out another case for survey or search out of that data.
Basically, what I have seen is what they can do is they can only copy the data with respect to that client only. They should not do anything further like seizure of whole system, whole server of the chartered accountant. Ideally, that should not be done. It is only the data of that client.
Theory versus practice is very different.
No. I understand what you are pointing to, but ideally,
there is a reason why we have taken these questions, because when actually some unfortunate one person may be subjected, it's not like it's going to be widespread. That person will firstly panic, may not know his rights.
Correct.
That is why we are discussing these things. So I also am not sure, because this 126 Evidence Act was enacted when only lawyers used to represent. Now the times have changed. There are in these tribunals other professionals also representing. Perhaps a case may be made out to read it further than what the words would otherwise admit. Let's move on as of now, because we have to complete. It's already, I think, 7:11 or something. Mr. Vaitheeswaran, next question is to you. There is a guarantee in the Constitution against self-incrimination. And is it applicable to records maintained by a CA when the CA is sought to be prosecuted? Does it make any difference that the record sought from the CA is before any show cause notice for prosecution is issued?
This flows from Article 20 And Article 23 provides that no person accused of any offence shall be compelled to be witness against himself. So that's how it flows, and that's how the self-incrimination concept comes into the picture. But there are consistent decisions which say that it will never cover voluntary statements. So practically, one will have to see what is the line of questioning and what is the statement that is given, and whether the statement is a voluntary statement. If the statement is a voluntary statement, then you cannot come back and say, no, I get the protection under Article 23.
To add to this very quickly,
Okay.
so there are judgments basically of Telangana High Court under Customs Act and everything, which says that before prosecution is launched, before this stage, when the proper officer calls you and summons you, you have the person who is summoned is not an accused and he is not a police officer. So whatever statement he gives would not amount to self-incrimination and would not fall within the contours of Article 20, and that statement will be admissible. And only when the voluntariness it is challenged, then only it can be tested during the trial, or else the admissions that are made before the proper officer, because there is a section 70 says that it is a duty of a person to state truth. If there is only any false information is given, then that person can be prosecuted again under 193 for giving false evidence.
Just 1 minute. Now the next question is for Mr. Garg. What precautions should CA generally take while advising or auditing clients? This is a very broad-based question. You can quickly answer it if there are some pointers.
So basically,
Especially advising clients. Audit requires a duty to be honest to the authority. Advising doesn't.
should be there. Firstly, the most important thing is not to assist the client in committing any of the criminal offense or reaping benefits thereof. And that is the main thing, because many times cases have come where there has been advisory by the chartered accountants. That is what is deposed by the person that chartered accountant advised me to do that to save the tax or do something wrong. And secondly, there should be clear reporting. As you already said, audit reports and all, there should be clear reporting. And if there is any such things that comes to the knowledge of the chartered accountant, it's his duty to report. It's always necessary that he should give a letter in writing that this is what you have to do and this is what wrong you have done. And if the client doesn't comply, then you should disassociate yourself with the client. That is what even the Charter to CA Act also says.
I will just add you one line so that question is very important, especially for youngsters who are getting into practice. Go by the law. Always go by the law. Interpretation is permissible. Unethical practices are not at all permissible. Have this as a guide. None of this problem will come.
Okay, sir. Then the next question is to Mr. Vaitheeswaran. Maybe Mr. Garg can also answer it. What are the precautions a CA must take if he apprehends arrest, except for anticipatory bail or running away from your house? Is there anything else?
No, good question. I will answer this differently. They say this: doctors should not treat themselves. Lawyers should consult another lawyer if they are looking at a transaction. Chartered accountants should not advise themselves. So even though they may be a master in that field, and when a problem comes, it is always better to have a third perspective and talk to a professional. And with my experience, let me tell you, with due respect and regards to my good friend Kartik Garg, tax lawyers are good in their domain of tax. Criminal lawyers are very good in the domain of criminal law. Criminal lawyers into tax, tax into criminal law is a tricky one. So a chartered accountant who needs help, if he rushes to the best tax lawyer to help him and save him out of a criminal action, will be given a lengthy advice as to what to do, what not to do, etc. But it won't work in a magistrate court. So you need the help of a criminal lawyer. Probably engage both so that the tax lawyer can translate the complex tax law to the criminal lawyer. Because you may not get a criminal lawyer as competent as Mr. Kartik, who knows both the tax law as well as criminal law so well. But most criminal lawyers are so thorough in IPC and CRPC, but if you tell them about tax, they say, what is this nonsense? What topic are you talking about? So you need a good tax lawyer or a tax chartered accountant who can explain what is the issue, and then probably the advice will be very good from the criminal lawyer.
Mr. Kartik, do you have anything else?
So if you ask me as a
prosecutor, can you say anything?
I only say that you should go and surrender yourself, or else as a defense. If you would have asked me 3 months back, I would have said file anticipatory will application or a rate petition. So it all depends in what
you're wearing at that point of time.
We forgot to say this in his introduction. He is the youngest public prosecutor appointed in the Bombay High Court.
Obviously, he's so competent. Definitely deserves it.
The present list. There may be earlier, but in
the next question is a bit tricky.
We can skip that.
Both of you
only procedure. We can skip that.
2-3.
Yeah, 22 we can skip because that's we have discussed that in some form.
No, 19. We'll not discuss all the other, but 19 I want to take your views, both of you, because this 135 is very peculiar. It says that under any prosecution for any offense under GST Act, which requires a culpable mental state on the part of the accused, court shall presume the existence of such mental state, but it shall be a defense for the accused to prove the fact that he had no such mental state with respect. Now, mental state and all, let's not go into it. Mental state basically is defined as intention, motive, knowledge of a fact, belief. Basically, mens rea. अपने को वही समझता है, mens rea. Okay, let's go to the next part of the question. What the provision basically says is that if I am accused of an offense, I have to prove the negative fact that I don't have mens rea firstly, and that also beyond reasonable doubt. Is this valid? How do you firstly prove a negative fact and beyond reasonable doubt? That is limited. We'll take only this question. The other 3 sub questions we won't take now.
So basically, I'll take some time in this, not more than 5 minutes. But so this is not first act, that is GST Act, wherein this provision is there. Similar provision is there in Income Tax Act. It is there in Customs Act. It is there in even NDPS Act. This has been tested. This provision has been tested before Madras High Court in the case of Selvi Jayalalitha versus income tax, whereby Madras High Court had said that this such provision is constitutionally valid. This has been even tested before the Supreme Court, though in NDPS Act, in the case of Noor, where again it was held to be constitutionally valid. Now the question arises, basically, what is this? What basically this would mean? So under normal criminal law, what happens is all the ingredients that have to be proved, the responsibility, the onus is upon the prosecution to prove that all the ingredients of the offences are present in the case. Now, if we see what onus has been shifted on the accused is only mens rea. So suppose we take it for example, there has been a supply of goods, there has been no supply of goods and only issuance of invoice with availment of ITC. In this, the prosecution will have to prove that first, there is no movement of goods, no supply of goods. Second, fake invoices have been issued. Third, ITC has been wrongly availed. So the offense is completed. The next ingredient which is required to be proved is with respect to whether the person had mens rea to commit that offense or not. So basically, there was some the report of Law Commission in somewhere in the year 1967, and that's how this provision come into the Income Tax Act, when whereby it was mentioned that it is next to impossible for the authorities to say that the particular person has any mens rea to commit that offense or not. Therefore, the responsibility onus was shifted upon the accused to prove that he didn't have mens rea. However, the rest of the ingredients has to be proved by prosecution only. So it will be responsibility of prosecution to prove that offense has been committed. Now the main problem here, what I can see and what the confusion is with respect to proof the term beyond reasonable doubt. Now this term beyond reasonable doubt can't be said to be similar to that what we find in criminal prosecution, where it is said that the prosecution has to prove a case beyond reasonable doubt, and the only conclusion that can be derived from the evidence is the culpability of that person. So here, as far as GST Act or even Income Tax Act, the term beyond reasonable doubt would mean that it is not enough for a person to say to only raise a doubt with before in the mind of the court. It has to be beyond that. It has that the doubt that is created should be reasonable and with some evidence to show that he didn't had that culpable mental state. So basically this has also been in some way explained in the case of Selvi Jayalalitha versus Union of India by the Madras High Court, which has said that sorry, which has said that which has said that it is that reasonable that beyond reasonable doubt it is not enough. So there is also a provision like section 138 of negotiable instrument act, that is check bouncing case, where wherein also the onus is upon the accused to prove that there was no legally enforceable debt or liability in such cases, but therein he has to only prove on the way of preponderance of probability, so that the probability what case he is putting is more probable than the other. However, in this it can't be on preponderance of probability. There has to be some definite evidence or in nature of document or some specific evidence that a person will have to prove that he didn't had the mental state at that time. Now if I give one example, I may be wrong while giving this example, but hypothetically, suppose I enter into any transaction with someone. I'm a supplier, I supplied goods or services. I promise, there is an agreement, so agreement or understanding that I'll supply goods and there is some amount fixed, and I received advance that the goods are to be or services have to be given in future, ITC is unavailed or some other further arrangement has been made, but due to some reason or for some dispute the goods or services are not completely delivered. Now in such scenario there will be case where there is issuance of invoice but no delivery of the goods, but there is due to the dispute between the parties. Now it can't be said that the offense under 132 is completed because there is no intention to that extent. So now it will be upon the accused to prove that there was such dispute between the parties. It can't be the prosecution, it has to be through the accused. And it is not just by saying that there was some dispute and therefore we couldn't the goods were not delivered. He has to by evidence, some evidence or by some probability, and beyond that reasonable doubt. Only by creating reasonable doubt is not enough. He will have to prove that fact to the court.
Okay, so we'll move on to the next question. We'll not take 22, 23 and 25 and the others also very quickly. We'll try to now finish them. Mr. Vaitheeswaran, if briefly you can explain this arrest before arrest assessment controversy. Because there were judgments in service tax saying that this cannot be done. Somehow now it is being done.
See, I believe this it's a very interesting point, because the make my trip decision, which is what you refer to in service tax, was quite clear that what exactly is section 73 talking about, what is the offense that is contemplated, if your punishment is linked with the quantum of tax. We just now saw that the punishment is linked to the quantum of tax, 1 crore, 2 crores, 5 crores, etc. How does that get determined? Now, in most cases, arrest happens even before show cause notice, even at the stage of inquiry after some point of time or after investigation at some point of time. And in most cases, when you go for an AB before the magistrate court, there are some records that are produced saying that the amount involved is huge. It runs to 40 crores, 50 crores, etc. But then there is no quantification, there is no identification as to how that amount has been arrived at, what is the basis for calculation, etc. So Madras High Court took a view in the case of Jayachandran that you're putting the cart before the horse, and that is not permissible. But if you look at Radhesham judgment of the Supreme Court seems to have endorsed the position that both are parallel lines, both are parallel proceedings. So the adjudication is one part, the arrest and prosecution is completely another part. So that is a law of the land as it stands today. But I would still feel that some kind of review is required either through the courts or by the parliament itself, that there must be a quantification. Without quantification, how can you assume that arrest is imminent and arrest is possible? Because you're taking away somebody's liberty based on this.
Radhesham is that Telangana High Court?
No, Radhesham is in income tax. Radhesham Kejriwal, I think sir is talking about. It is under
Radhesham
income tax. But in Income Tax Act, no provision of arrest. We have provision of arrest under GST Act. So according to me, before this GST Act, under Finance Act, there was two judgments of Make My Trip and Clear Trip of Delhi High Court and Bombay High Court, and Make My Trip has traveled to Supreme Court, and Supreme Court has said the view taken by Delhi High Court is correct. Now that Finance Act provision and GST Act provision are pari materia, it's almost the same. So basically that Make My Trip judgment may also apply, but now the Telangana High Court and Rajasthan High Court, few high courts have taken a contrary view, saying that Make My Trip will not apply, and relying upon Kejriwal, Radhesham Kejriwal judgment, they have said that it can run parallelly. Again, there are different views, as sir said, Jaychand, that Madras High Court judgment has taken a view. Even Punjab and Haryana High Court has taken a view that it ideally it should adjudication should be before arrest.
That really brings us to the next question. Yes, sir.
No, in fact, income tax has always approached that principle that the quantification has happened, seriousness of the offence is well established, and then prosecution is lodged.
Then arrest is not there. When arrest is there, that extra necessity of protection should always be there. That's what I feel. But then again, open for judicial interpretation. The issue is pending before Supreme Court. This issue is also pending.
My humble sense on this is that arrest should not be used as a tool to coerce payment.
Correct. For recovery, it can't be used.
Now that really brings me to the next question, because I have always wondered, what do these people get by arresting? Arrest, they say it's for the purpose of investigation, but from the limited knowledge of criminal law, I believe the police first get custody, judicial custody is there or police custody is there, whatever it is there, but it is not the GST department which gets custody. Even if it is the police who are investigating, what is the use of this arrest then? Are they really, do they have the time to, police, do they have time to investigate input tax credit matters? I don't know. You have to throw light on who actually gets custody, who is investigating after an arrest. When I read these bail applications,
there is no judicial custody that is granted in these kind of matters, or there is police custody or those kind of things. Arrest happens. If arrest happens, then if bail does not happen, the person simply languishes in jail, and whatever term that happens. And after a point of time, the investigation concludes, and so on and so forth. But because of the arrest, the investigation does not become stronger, or non-arresting does not make the investigation weaker. So they continue in different proceedings, but arrest, as I said, has got a stigma to it, and therefore there is an apprehension that the threat of arrest might work wonders.
So, Mr. Garg, they don't put you, this arrest does not result in your normal CRPC process of police and judicial custody?
So basically, GST officer is not a police officer. If he is not a police officer, there is no question of police custody. So suppose a person is arrested, he is produced before the magistrate within 24 hours. So that is only that 24 hours he will get when the person will be within his custody. After that, after he is produced before the magistrate, what is granted is judicial custody. He is sent to the prison, not to the police station or to the GST officer. So there is no question of police custody in such things. And with respect to the purpose of arrest, so basically Telangana High Court, and even there are few high courts which have said the purpose of arrest can not only be investigation. the purpose of arrest. So there may be instances where investigation cannot be possible if the person is outside, or there is an apprehension that the person may tamper with the evidence or flee from the justice. So there are 3-4 more categories in which the person should fit and for which the arrest is made.
Therefore, after judicial custody, the GST department has no access to the accused.
No. So if they require to cross-examine, so if they require any information or interrogation, they will have to apply before the magistrate. They may send questionnaire and then all meet them, but it is not strictly as such a police custody. It can't be a police custody.
Okay. Then question 24 to Mr. Vaitheeswaran. This 73.5 and 6 and 74.5 and 6, you made certain payment and then that show cause notice is dropped. Does it save you also from prosecution, or you are independently still liable?
I think the same question which we just now answered, Jayachandran versus the Telangana High Court view. Madras High Court versus Telangana.
Yes. Yeah. Okay. And last question to Mr. Vaitheeswaran, which Mr. Garg can also answer. Because in Bombay High Court, these GST matters, Arnesh Kumar, something is going on, which he may be able to answer from Bombay perspective. Mr. Vaitheeswaran, are the protections in Arnesh Kumar judgment available when CAs or their clients are arrested? If you can just explain briefly what this Arnesh Kumar is.
That decision gave a set of guidelines which has to be followed in the context of upholding the liberty and the police officer's duty and responsibility to indicate, and some kind of clear record being available, chain of events being available to demonstrate that the offense as identified has been made out, etc. I have my doubts how much of it can extend to GST law, given the language of power to arrest, given the language of 135. I doubt if those principles will so equally apply.
Okay, sir. Mr. Garg, there are some matters which I believe were going on before, some 6 months back, before Justice Bhuyan, on this Arnesh Kumar, whether it applies to GST arrest. What is the status, and otherwise also what is your view?
No, now status is I can't pursue that matter right now because I am on the other side. But the brief background of the law is this. So there is a provision under CRPC section 41 and 41A. Basically, what used to happen earlier, pre-2005, is that for each and every offense, when the offense is non-bailable, police used to go and arrest, even for petty offenses. So legislature came with an amendment, I think in 2005, somewhere 2005 or 8, whereby they introduced section 41 and 41A, whereby they said that when the imprisonment is 7 years or less than 7 years, you can't arrest a person automatically. You can, and there is another section 41A which says that before making an arrest, it is mandatory that the police officer shall give a notice, a summons basically, to the person, and if he cooperates with the investigation, he shall not be arrested. And if the police officer still wants to arrest him, there has to be reasons recorded in writing. Now this provision will apply whichever act it is, when the punishment is less than 7 years or 7 years. Now under GST Act, the punishment is less than 7 years, then the maximum punishment is 5 years basically. So according to me, this section 41 as well as section 41A will apply. Now this section 41A has to be read with section 70 of the GST Act, which requires the proper officer to issue notice, issue summons to the person. So basically the view that has been taken even by Telangana High Court, and this is the only consistent view right now, which I feel amongst all the high courts, that you can't arrest a person directly. First you have to issue summons under 70, which has to be in consonance with section 41A, because the punishment is less than 7 years. If he is attending and cooperating, you should not directly arrest him. There should be reasons if he is attending and cooperating to arrest. And there are few categories, again this similar thing, that investigation is not possible if he is out, or if he can tamper with evidence, or if he can flee from the justice, then only he can be arrested if he cooperates with the investigation. If it doesn't cooperate, then it's always open. But nowadays it's what is seen is, without summons or without notice, the GST officers don't really arrest any person. So always there is first summons, there will be 2 to 3 summons. When they are satisfied that this is a case where the person has to be arrested, then only they arrest. And there is again one more that we already discussed, section 16, and that there should be reason to believe. That should also be there. So that a little protection is given by the legislature to such arrests.
Okay, so that concludes our session on our panel discussion on this analysis of criminal provisions under GST. I thank both the panelists. I hand over the proceedings now to Mr. Kasar, I believe, or Mr. Maheshwari.
Yes, Dwani here. Wow, what a wonderful, engaging session. Thank you so much, Advocate Kartik Garg. Thank you, Advocate Vaitheeswaran ji. Thank you, Ishaan ji. Thank you all for your valuable time. Thank you for helping us walk through the various criminal provisions of the GST Act with the light of law. Your contemplation on various provisions and judgments applicable under the GST law has, I'm sure, made it very fluid and more simple to interpret for all the members present here. So without much ado, I would like to extend our heartfelt gratitude to all the esteemed panelists for your presence and for your valuable contribution. Thank you, Aditya ji, for coordinating. Thank you, all of you. Thank you so much.
Thank you so much. It's been a pleasure interacting with Mr. Kartik as well as Ishaan. Thank you.
It was a pleasure. Thank you.
I would request that this panel, I don't know what is the policy of WRC with respect to these recordings, because so much has been discussed and all of these are useful tips for all CAs. You may perhaps release it even for general consumption of all chartered accountants.
Certainly, we will.
Some of them have taken a
It's
lot of
hosted
effort.
on the WRC channel also, YouTube channel. It will be hosted on the
Yes,
YouTube
sir.
channel.
Yes, sir. Thank you.
Thank you.
Sir.
Thank you.
Thank you.
I should be log off.